All right, welcome everybody to the OOR Sunshine Week webinar presentations. And we'll get started at 2 o'clock, but just making sure that everybody can hear me and everything's good. And we'll get started on covering the substantive nature here in a minute. All right. Good afternoon, everybody, and welcome to our webinar for today. Today, we're going to be covering the issues of submitting evidence in an OR appeal to the Office of Open Records. My name is Nathan Byerly. I am the Deputy Director at the Office of Open Records. I am joined by our Chief Counsel, Kyle Applegate, who is, in addition to being Chief Counsel, an appeals officer on various appeals and has been an appeals officer for years and handled lots and lots of appeals. And we thought it best to bring him in today to answer some questions as we go through, as well as to give his perspective from an appeals officer's viewpoint of things that can be improved and done better by agencies and even requesters when they need to submit affidavits, evidence, and various things to the appeals officer. So with that, we'll jump right in. Kind of as a roadmap for today, some of the topics we want to go over is why is an affidavit needed? I mean, why in the first place do you even need one? Want to walk through what it is and give you some steps and walk you through how to write one and how to write an effective one. Before we get into that, some of the terminology I want to go over is acronyms I may use and terms I may use. AO is an appeals officer. Sometimes we call them AOs. Sometimes we refer to them as appeals officers. FD is a final determination. An arrow is an agency open records officer. I may, or Kyle may also refer to this person as an open records officer without saying agency open records officer, but they're all are the same and the one. Affidavits. I know there's some back and forth on this, and I'm going to ask Kyle a little bit later to jump in and talk about that. In one of the parts we talk about that is, and that's the difference between attestation, statement of fact, affidavit. At the OR, we use them interchangeably. They can be in the legal realm be different, but we treat them all the same and use the same terminology. You know, whether we should or should not do that from the context of, you know, the technicalities of it, we still do it. So if we talk to you about submitting an affidavit or an attestation, they are one and the same. And just an overarching purpose in this is to improve everybody's efficiency. You know, if you give a good affidavit, that helps the appeals officer work through the appeal that much quicker, and it also will prevent them from having to come back to you for additional information. We see a lot of affidavits that we'll talk about later are conclusory. Those then go up to the court. The court may look at it and send it back to the Office of Open Records to collect some additional evidence. Again, that's an inefficient approach to it, and we want to try to avoid that as much as we can. We also want to assist agency open records officers. The OOR is here to be a guide and be a help to the extent that we can. We can't give legal advice, but we really do want to be in a situation where we can give the arrow the resources that they need to be able to navigate the appeal process. So, and I'm going to ask Kyle as he sees fit to jump in and comment. So he may be jumping in from time to time. And as you have questions for one or both of us, please feel free to type that in the chat bar and ask us those questions. To the extent that we can, we'll get to them and answer them. If we don't have the opportunity to get to them, please feel free to follow up with our office after the fact, and we will try to the best of our ability get you the answers and the resources that you need. But first of all, jumping in, why is an affidavit even needed? And the burden is on the agency to show why the records should not be released. That was what the new what we call the new right to know law, even though it's been 13 years now. That's what the new law shifted the burden to the agency. And affidavits are how the agency will detail, support, break down, and show why an exemption applies to a certain record. It is evidence. It is your testimony as the person making the declaration, making the attestation, making the statement of fact. That is your statement. So it's very similar to giving testimony before a court in gathering the evidence from the appeals officer standpoint. And people ask sometimes, well, why do you do affidavits, attestations versus having an actual verbal live in-person hearing? And we do have the ability to have those hearings, but a number of factors, some being cost, some being turnaround time, really being the biggest, where there's not really time. We have 30 calendar days to issue a decision, and trying to schedule everything and get the hearings to take place would be a problem in and of itself. But the Commonwealth Court has said that the way that we collect evidence through the written form and through the affidavits and attestation is acceptable, and due process is protected in that approach that we take there. And the affidavits and attestations, they're given the same weight as verbal testimony. So just like, if you were to come into a hearing and testify before us, the affidavit or attestation is going to be considered the same by the appeals officer. In most cases, and there's some situations where there's a black letter legal reason that may lead to a different final determination. But in most cases, if the agency fails to file a sufficient affidavit in support of their legal argument, likely going to fail to meet the burden, and the OOR will grant that appeal. So the practice tip here is when an agency files an argument with the OOR alleging anything, alleging that the record should be withheld, alleging that it does not exist, you should always support that with an affidavit. We see time and time again that if records don't exist, sometimes agencies will think, well, we don't have to submit an affidavit to support that. Even in the do not exist situations, you need to explain that the records don't exist. Same standard applies to a third-party direct interest participant. It's good to let third parties know. If you have, records of a contractor or something, it's good to let them know that if they want to step in and litigate and show why an exemption should apply and that record should not be released. A lot of times we see this in copyright cases. The same principle applies. They need to give us the affidavits and attestations to explain what's going on and why they think the record should be withheld. All right, we're having issues here. All right, I'm having some technical difficulty. There we go. So what is an affidavit? And before I move on to that, Kyle, do you have anything to add to it? Okay. No. What is an affidavit? Affidavit is a factual statement, and I'm going to see the emphasis here. Factual statement made under oath or penalty of perjury. It claims that a fact or set of facts is true to the best of the affiant's knowledge. So it is a statement of fact. And the reason we emphasize that is typically, and I would say as lawyers, but it's almost as people, we tend to go into an argumentative mode and want to make arguments or make explanations for why we're coming to a certain conclusion. So we will jump over what's going on in a case and instantly start defending our legal position. Before you get to that in an affidavit, you need to establish the facts. So to further clarify, it's a statement that can be verified objectively or proven. The email was sent on May 10, 2020 at 4 p.m. The letter was only read by John Doe and Jill Smith. It was not shared with anyone else. Those are facts. Again, it's a factual statement, not a legal argument. Your legal argument is the email is not a public record because it's exempt as an investigative record. And instead of saying, the email was sent on May 10, 2020 at 4 p.m. and was part of an investigation, that would be a factual statement that would be supporting of any legal argument that you're going to make. Legal conclusions, arguments, and opinions that a person making the affidavit would make in a letter brief, those should be made. Any argument should be made in the letter brief, not the affidavit. Again, emphasizing this, only facts in the affidavit, don't argue your case. The affidavit supports the legal arguments with facts, and it should not make legal arguments. I'm going to let Kyle, you want to add anything to what you see as an appeals officer? Do you see this come up in not final determinations, but in submissions from the parties? How does that work with them doing that when it comes to an appeals officer? What's an appeals officer's reaction to that type of scenario?
Sure. It's so the affidavit or attestation is complementary to any legal argument that you're making, in that it is, the factual component of the argument you're making. And any brief or email or submission you make, that's where the legal arguments are set forth. So, there's a relationship between them, and to the extent you can avoid commingling, that's appreciated on behalf of an appeals officer. Nathan's correct that we're looking for facts in an affidavit or attestation, because it's evidence. We're looking for factual statements that are supported.
All right. So moving on, and again reiterating that and giving some examples. Factual statements, not conclusions. One of the other things we run into, as well as legal arguments being made, is that they are what the courts have called conclusory affidavits, meaning they basically skip steps and come to a conclusion instead of setting forth factual events. And examples there are, the requested email was deleted on April 7th, 2018 as part of the county's record retention policy. That would be a factual statement versus just coming to the conclusion and saying, oh, the requested email does not exist, or the records don't exist. So keep that in mind as you develop your affidavit, that, like I've said earlier, even in the do not exist scenario, you still need to present evidence that shows that the record, to the extent you can, does not exist. Again, a follow-up factual legal argument conclusory statement there. I'm not gonna read it, but that's another example of where a conclusory statement is not sufficient. It can also be a little more, and you come to those conclusions, and it can become even more a little sophisticated than that, and you need to walk it down and explain why something happens. So in this situation, with this example before us, the requested list of weapons, ammo purchased will jeopardize public or personal safety. And you can look at that and think, well, yeah, we don't want to give out a list of how many weapons or how many ammo or where they're stored as a public record. That's a safety issue. But you're going to have to establish, well, why is that? And walk the appeals officer, and potentially, if it goes up on appeal, the judge down the road to say, well, why is it a threat? If we give out this information, every potential criminal could get this information and could make a move on trying to obtain or take or use force to get those weapons. How would this create a threat? It gives them an opportunity to select which armaments may have more ammo or guns than another. And how does it relate to the current request? It ties into it, because this is an actual request for those items. And it's good to paint that picture for the appeals officer as they work through it.
Some advice would be to never leave anything to inference. So please don't just assume that the appeals officer is going to be able to link a threat of harm to the facts of your case. We're looking at the person making the affidavit or attestation. We're looking for some sort of expert knowledge explaining it to us. So please don't leave anything to inference, to try to have the appeals officer figure out themselves.
So actually going about and writing an affidavit, and I tag this the pre-drafting stage. My first suggestion is put yourself in the place of the appeals officer. The appeals officer probably doesn't know the facts or history of your case. And even if you're a repeat filer or agency that's been before the agency or before the OOR many times, last year we handled 3,000 appeals. So the likelihood that an appeals officer is going to remember the history or facts behind even a pre-existing right to know request involving your agency, it might be slim based upon the numbers. Break down the acronyms or specialized terms you use. To say Form 123 may mean something to you. If the appeals officer doesn't know what that form is, we're left guessing what that form is, and you really need to break down how these specialized terms and forms relate to everything, especially with the acronyms. I mean, government's notorious for acronyms, so break down what those mean. There may be special or unusual circumstances surrounding the request. Those are always good. Again, names and files, loan application equals Form 27B. Explain what Form 27B is, that it is a loan application. Explain the contents of the records. You don't need to go into any great detail, but the appeals officers appreciate knowing what's in the records, what's the subject, what's the substantive content of them, because they're going to have to apply the exemptions and determine whether or not those records are public or not. As far as storage, filing, and backup system, as to whether or not the agency is creating a new record, this will tie into the storage of data and whether extracting that is creation of a new record. It may also impact whether records exist, depending on what type of backup system. If records have been deleted and no longer exist, you need to break that down as to how your servers might work and why the emails that the requester is seeking no longer exist. Agency's retention schedule and policy. If you're following your retention schedule and you have records that don't exist, it's very easy to say, hey, we deleted them in accordance with our retention policy on this date, and here's our policy that supports that and permits us to do that. Unique nature of documents. On any given day, we see appeals that might involve unusual documents. Break down, why those documents are unique, what format they're in, and how that affects your ability to produce them and provide them, and how that affects the application of the exemptions to that specific document. And terms of art. There's any number of terms of art that might be used in a particular field. The right to know law touches many different aspects of life. We were just talking about that today. And you get the construction code, education, taxes. I mean, you pretty much name it, and government will potentially have some type of record impacting that area. So we're going to run into a bunch of terms of art. So make sure you explain what those may be. The appeals officer only needs to know what is applicable to the case. So there's no need to talk about irrelevant details surrounding the records. Sometimes we'll see agencies and requesters that have a long storied history. We don't need to know the whole history. All we're looking at is what records are public in this context. And just an overarching suggestion is be a guide. Tell a story. Walk the appeals officer through what's happening and provide those details to the appeals officer so that they can make a decision. Anything to add to that, Kyle?
The only thing I would add is, please don't worry about, worry about insulting our intelligence or something. If you have a term of art or an acronym, please explain, what it means or refers to. It's often very much appreciated.
As far as the structure goes, and these can be very nitpicky but very important. Make sure you include the caption and docket number of the case at the top of the affidavit. And I got the examples sitting there, but handling literally dozens of these at a time, the appeals officers really appreciate the organizational skills that you demonstrate by putting these types of things on the affidavit. Here's where I'm going to let Kyle jump in and indicate that the affidavit is one of these three. And this is where you get into your affidavit, attestation, statement of facts component of this.
So to keep things very general, affidavits and attestations are generally separate legal instruments. They're different kinds of documents. Affidavits are generally, sworn to in the presence of a notary. There's the fancy seal at the bottom from the notary. Attestations are self-executing, which means the person filling out the attestation is the one kind of verifying the accuracy of the facts. They'll include slightly different language, but what we are looking for as an office is some kind of acknowledgement, knowing that you are facing criminal penalties essentially if you're misleading us. So any of this language will essentially work to serve that purpose.
And just looking back at the history of that, where we went with that early on was when requesters would file with agencies, it was often said that all these records don't exist, all these records don't exist. And we started requiring these documents to be filed, one of these types of documents to be filed that would result in criminal penalties. And suddenly records started appearing and records were being found. So it is a necessary component of it and helps and assists the appeals officers greatly. Arrange the facts in a coherent manner. Try to pay attention that you're following the dates, or if there's a different organizational way that makes more sense in any specific appeal, just make sure that you follow through and that it's a clear-cut, easy to understand presentation for the appeals officer. The use of separate paragraphs and numbered paragraphs as you present that to the appeals officer is very helpful. Try to keep each fact to one paragraph and one numbered paragraph. It's easier to read, it's easier to reference in the FD, and it's easier to reference if the final determination goes up to a court of appeals for decision, because then the court can also reference the same paragraph numbers and the same facts as they work on their decision as they review the appeal. Reference any supporting documents, mark them as exhibits. Again, this is important. Try to keep each document. Okay, I got a question. What types of legal action occur if someone is misled, lied in an attestation? We obviously, as the Office of Open Records, we don't have jurisdiction over criminal matters. So you would take that up with the local county district attorney is who you would contact. There may be situations within Commonwealth agencies where the Office of Attorney General may be a place to stop as well to ask for details, but typically it's the county district attorney.
Yeah. I think the crime that would be at issue is unsworn falsification to authorities. Generally, that's governed by the Crimes Code 18 PACS 4904. I think it's a misdemeanor of the third degree. There's an intent aspect there, but the ultimate decision is made by law enforcement.
And I don't know of any situation where that's occurred.
I can't think of it.
Yeah, I don't know of any situation where that's occurred to date involving the right to know law. Jumping back into the structure, reference any supporting documents by marking them as exhibits. Again, this is as important for organizational purposes as it is with the numbered paragraphs. It makes ease of reference it just makes it easier to reference, and also, again, helps the courts if it goes up on appeal. Use a reference or index where necessary. There'll be sometimes when an appeals officer will request a index or a Bates stamped copy, dates, numbered pages is best to go with those again to keep that organizational and easy for the AO to reference. Anything there? Okay. So in actually writing it, the affidavit should include the name and title of the person giving the testimony or making the statement of fact, and that helps show, why it's important that the person telling the appeals officer these facts. So why do they know? Why do they know where the records are? Do they know where they're stored? How would they know where they're stored? Why would they know where the records are, or why would they know what the records contain? You don't want somebody who has no idea what's in the records or where they've been kept or has no knowledge of the case making an affidavit. You want somebody with knowledge, and the affidavit will establish that as you lay out the title and the responsibilities of the person making the affidavit. What would they know about the facts or situations surrounding the record of request? What information can they provide to the appeals officer that is helpful? And a lot of times, you're looking to establish the nexus between the exemption and any withheld records or redactions. So you're trying to connect the two together, connect those dots. You're also trying to show in the do not exist situation why the records don't exist. And I generally encourage people to just kind of run down, right before you start writing the affidavit, write these questions down: who, what, where, when, how, why. Typically, if you answer those questions with facts, you will be able to produce an affidavit that will walk the appeals officer through the process. Now, I fully concede you're probably it's going to take more than a couple sentences to answer that in some cases, but these give you a framework, and if you keep asking yourself, building upon each factual statement, these logical questions, you can put together an affidavit that will A, meet your burden, and B, help the appeals officer work through the process.
Yeah. And going back to the previous slide, those are all good questions to ask yourself while crafting an affidavit or attestations, because those questions are going through the appeals officer's mind when they're reviewing it. They're looking for credible evidence. So, they're looking for an affidavit or an attestation that, gives enough clarity to these questions.
So moving along to writing an example or writing an affidavit and examples of it. So we look at a records do not exist or are not in the possession of the agency. And this is always one that I have the asterisk there because I always try to say something. It's a terminology that we've used from the beginning of the law that is unfortunate. And many times we will see cases where it's not an issue of the records do not exist. And the awkward way to say it is the records do not exist in the possession of the agency instead of just saying we don't have them. So I raised that asterisk just to say, basically, in a lot of records do not exist cases, it's not necessarily the records don't exist, it's that the agency doesn't have them. So feel free to clarify that when you're writing your affidavits. And if you want to drop the records do not exist in the possession of the agency, if you want to drop that language and just say we don't have them, it would be fine with me. Do you agree, Kyle?
Yeah, fine with me as well.
But I know there's 13 years of us having said that over and over again, so it's probably not likely to happen in a lot of the situations where I as much as I wish it would, it probably won't. But in any event, so you're developing a situation where you have records don't exist in your possession, you don't have them. How do I prove a negative? So some of the questions you would look at is, who looked for the records? Where did they look? Why did they look there? What records did they look at during the search to try to see if the information even requested was not available? Who would know if a record was never created? I mean, that can be your best support in a records does not exist case, is explain it's impossible for these records to exist, or the record was never created. And here's who knows. Another thing is to explain what keywords you used as part of your search. If you have a big set of documents, like say a lot of emails, and you're trying to find if responsive records exist, when you present something to the appeals officer, say, hey, here's the keywords we used. If the record existed, these keywords would have found them, and we found no records using these keywords or these search terms. That can be very helpful to the appeals officer in determining what records, if records exist or do not. Where else would the records be? Sometimes you'll get a situation where you'll get a right to know request and you don't have the records, but another agency does. It's perfectly fine to say within that affidavit, and really helps the appeals officer, these are not records we generate. I mean, if you went to the Department of Education looking for records that the Department of Transportation was creating and have, you would just say, we're not, the Department of Education is not in possession of these records because we don't oversee transportation issues. That could be a good example of how that might work if another agency has them. And then point the person, in light of good government, point the agency to the Department of Transportation and explain to them they could reach out to the Department of Transportation and file a right to know request with them. Were all the copies destroyed or deleted? With retention policies and with, especially in the day and age of electronic records, there will be emails that will be deleted. Explain to them if they were deleted, when they were, why they were, and by whom they were deleted. That will help the appeals officer also be able to support their final determination in writing if the record does not exist. And explain again what the agency retention policy is. That helps the appeals officers well understand the context of what's going on in your agency, that these records are deleted on a regular basis and therefore may not exist. We see situations where videos are overwritten after a certain amount of time. If there's requests for video footage, explain all of that to the appeals officer, what your policy is, what the time frames for the overwrite may be. Same with backup servers and backup tapes. I know that's becoming more and more obsolete, but those are other potential areas where you're going to want to explain how a process works and how data and information may be deleted or overwritten. And again, I already mentioned this earlier, but good government tip: if you don't have the records, but you know who has them, please send the person to the right place for the records so that they can go and make the request in the right place.
One thing to be mindful of is the fact that the level of detail that you might have to include might differ depending on who is making the affidavit or attestation. Like, for example, if the question and issue before the appeals officer is whether or not zoning records exist, an affidavit from the director of zoning might be, more value and require less explanation than an affidavit from a secretary or an open records officer who is kind of familiar with the zoning records, but not that familiar and might have to search a little bit harder to conclude that records don't exist.
So there are various case laws. Oh, got a question. That affidavit is only to use during an appeals process. Correct. You are not required to do an affidavit or an attestation in response to a request. It would only be during the appeal process. Sometimes it may be beneficial to do an affidavit depending on the relationship between the parties. I have from time to time seen, especially in the do not exist context, where a requester may not believe the agency that the record does not exist, that the agency will provide a affidavit attestation at the request stage just to try to avoid there being an appeal, just to get that affidavit. If the agency has no retention policies, do state retention policies apply? I'm not sure about the retention policy. I know that there are recommended guidelines by the Museum and Historical Commission. I believe they would govern. However, as far as our impact goes and how that impacts us, we look at whether or not the records do not exist. So if they were incorrectly or inappropriately deleted or discarded, we don't have jurisdiction over that. Our inquiry would end there because the records don't exist and therefore cannot be accessed under the right to know law. I'll touch base with me after, or email me or Kyle or George Spees, who's our training chief, about the state retention policies application. I don't recall right off the top of my head if they apply when a agency doesn't have their own. Do you recall?
I think the PHMC's
PHMC's governs.
Generally
governs. Okay. Well, there's your answer. Generally governs over everything we're going to. And I think if the retention policy is less stringent than the PHMCs would still govern. I mean, you can't overdo their retention policy, I would think. So I hope that answers your questions. If not, feel free to reach out, like I said, to me, George, or Kyle. There are a number of cases that govern affidavits that have come down over time. I'm not going to go into any detail on any of them, but it is good to look to them for guidance from time to time if you're developing your own affidavit. We have so many final determinations that we've issued over the years, and there's been a number of court decisions that is very likely that you'll be able to find a case that, or at least the type of record that's very similar to yours, and then you can look at how the final determination handled the affidavit and see that as a good example of how to frame your affidavit as you respond to an appeal or even a right to know request. So what I wanted to do was jump in and go over, just walk through an actual affidavit that was filed with the Office of Open Records that was successful. I'll do a little bit of a spoiler here and say this was a do not exist case because some of that will be relevant as we walk through it. But jumping right in, caption is there on with the names of the party. They give the docket number. It's at the very top, which makes it very easy to reference and see for the appeals officer. It gives the name of the person making the statement of fact or the affidavit. It says it's pursuant to one of the sections that we like to see referenced. It also references the being based upon their personal knowledge, information, and belief. It identifies their position and what their title is within the agency and why that's important. It gives their experience level. Basically breaks down that they would know where the records are. Gives their duties, again, giving credence to they would know where their records are. They would know if those records existed. Moving on to the next page. This is helpful to the appeals officers as well. Not necessarily required, but again, you want to help the appeals officer as much as you can by giving a procedural background and giving the history of the request, what records are requested, and then explain how things have transpired since then. You know, this is a very short and to the point one. Sometimes your affidavit may contain a few more facts and procedures and things that have gone on behind the scenes, working through the process of the right to know request before the agency. And very important on this one is paragraph 8. You know, waiver of representation by counsel. That is their form PBPP72. Every time I do this one, I can't help but think that PBPP72 sounds like a Star Wars droid, but in any event, it is not. It is a form within the Department of Corrections. And the affiant here does a very good job of explaining what that form is. Explains the location of where the records would be if they existed. This is important too, because it again demonstrates and gives more credibility to the fact that this person went and looked where the records would be. So the person knows where they would be, they looked where they would be. And on this one in paragraph, I believe it's 9, or is it 10? No, paragraph 11. He went and looked in the old file management system to determine if a paper file remained. So if you knew that there was paper files potentially maintained that contained responsive records, you should go look at them too and explain to the appeals officer, hey, I went and looked here. Additionally, on this one, the facts are given that show that this record would never have been created anyway, because this inmate never appeared before never appeared before the board for a preliminary detention, violence, or revocation hearing. So this record would not exist anyway. And then reaching the grand conclusion, then after a careful review of everything, the record does not exist. I think this one exemplifies a very good way to walk through showing a record does not exist within the agency. And Kyle, would you agree?
No, I would agree.
Anything to add?
No.
Okay.
I mean, it's If you're an open records officer and you're the one conducting the search and writing the affidavit or attestation and swearing to the facts therein, this is a good guide for the level of detail that you might need to provide.
And here's another one that we had a little bit different, a request for a spreadsheet of all sign permits. There should be 6,000 sign permits on this list. So again, I don't have the actual example posted before you, but these are excerpts from it. The person gives their title and why that's important. I'm familiar with the records. They lay the foundation for why or why not they may have the records. One of their responsibilities is to issue these sign permits, so it makes sense that the request was made to the Department of Permits, Licenses, and Inspections. In this situation, the individual explains the search in this way. He's like, I conducted a examination of our files. I searched for the paper files. I searched through the digital files. So again, you have a situation where a person who knows where the records would be stored has shown that to the appeals officer that, hey, I'm the one who would know where these were. I went and searched in these places, and after looking, I have concluded that, the spreadsheet we provide in this case is the only responsive record for this request. And you really have to be careful in these not to skip the steps and just go to, right, I went and looked and they're not there, because the courts have specifically said, I mean, it's not the OOR that's coming back to you saying we need more detail. The courts have specifically said it's not enough to just say I looked and they weren't there. The courts want more detail on the type of searches that are conducted. Again, here, as I said earlier, it's good to explain to the appeals officer what records are being requested, and it may be necessary for you as a affiant to explain how the different types of records and how the records are stored impacts the information that's being requested. This is a spreadsheet. There gets into a little bit of a explanation for why it includes, several signs in one submission for a sign permit, and there's a slight discrepancy between the two spreadsheets. You may need to explain discrepancies like that and why information may be available in one record but doesn't transform over to another. And again, that's knowing the factual specifics of your case and explaining that to the appeals officer in a way that they can understand. And then again, breaking down, in this case, explaining in a little more detail why the record does not exist. And as you can see right there, I'm not going to read it to you, but the affiant here was very specific in explaining why the information that had been requested does not exist. And again, making it easier for the appeals officer to work through and reach a decision. We have a number of sample affidavits on our website. Some of those you can, just use very easily. I look at those examples as patterns. You want to use them and build off of them. Don't expect them to just be a end all 1, 2, 3. I fill in the blanks and it's done. You're going to need to add facts that may be specific to your specific situation and the specific records that have been requested from your agency. So again, walking through another example of an affidavit supporting this. We've seen one where the records do not exist, but we also have situations where exemptions are cited. So they may say, in this example, it's a request for a surveillance video, and the argument was, well, the release of the video would threaten public safety and it would endanger safety of people because it would show potential issues with security. So in walking through how to support that, it's not just enough to say it's a risk, it's a security threat. Your questions and the answers to these questions should at least include what's in the record that makes it a threat or risk. Why or how would release of that cause an issue for security or for safety? Can the information be redacted? There's been Supreme Court holdings that video can be released and redacted. So if you have in your agency videos, or you have surveillance videos that could potentially be redacted, it may be time to consider looking at some redaction, or it's more blurring that goes on. I know YouTube has a feature that does it, and it's relatively free and easy to use from what I understand. So that could be something to look into as an agency, that, for these surveillance videos or for any type of video that might be requested, you might want to look at redaction or blurring capabilities within a software program. Who is attesting that there's a threat or risk? I mean, you're going to want to look at that person's experience, their expertise, their knowledge of a situation. I will tell you from the cases that we've had relating to video, it's typically pretty difficult on the surveillance video side to establish, and especially the outside ones, to establish that there's any security risk, mainly because the cameras are taking pictures of public places. So you could easily sit outside and observe the same things going on that the video footage is going to show. So if events and security details can be observed from sitting outside, then how is there any worse threat of releasing that video to the public? And those are the type of exemption issues you're going to face if you try to establish that there is a threat to public safety. And this is a specific case that dealt with that. This was the Gregg Township versus Grove case. The court ended up holding that the agency did not show that the security camera footage was exempt. It held that it was a public record. And some of the things that it pointed out with the affidavit was that it was silent as to what was depicted in the video. So it didn't explain how anything in the video would cause a threat. So again, there's your why and how questions that you're trying to answer. It referred generally to all the cameras being a security issue, but it didn't explain why footage from one camera caused a threat to safety or security. So if you have a video request ever come in and you're in this situation, remember, if you have 4 or 5 videos or video cameras set up, you should explain why each angle released would cause a security threat released on its own. You're going to want to address each one and not just generalize and say all of them. It didn't address whether the information could be redacted. Again, as we make more and more advances in technology, these tools are available to redact and blur out information. And again, full of conclusory affidavits without explaining details. The courts have been very, very emphatic on conclusory affidavits, and they've even reached the point where they won't let, depending on the situation, they will not let the agency submit additional information before the court on appeal. And they will say, you should have submitted that information in an affidavit to the Office of Open Records. So it's important that you submit these affidavits to the OOR so that we can take a look at them and decide on the facts. You have anything to add?
Yeah, I would add that appeals officers often see kind of deficient affidavits and attestations when dealing with the security exemptions. And I think part of it is, if you're an agency and you're you're the person writing this affidavit and you truly believe that there's a security risk, I think it's easy to get in the trap of leaving out some of these important details and giving us an affidavit or attestation that's kind of conclusory, where you might get in the mind of how can anyone in their right mind not think that this is a security risk? But we need the evidence that sets that encompasses all these steps to get to where you need to go.
And that's why when we get into the next step, which is editing, I encourage everybody to take, if you have the time frame to do it, set it aside for maybe an afternoon, set it aside for a day so that you can go back into it and maybe avoid some of the pitfalls that Kyle was just saying. You're reading into it and say, well, how can anybody not see that this is a threat? And then when you take a step back and go, oh, well, I'm missing this fact and I'm missing this fact. If you have a little bit of time in between writing it and editing it, that might help you. And I understand completely that there are time crunches on this. So, I mean, if you're able to reset your mind in an hour or two, that hour or two break might even be worth helping. But reread and edit your affidavit. proofread for the accuracy and grammar. This seems counterintuitive, but it needs to be done because the dropping of one word, spell check's not going to pick up on it, and your grammar check on your computer and your Word is not going to pick up. So you could say the records requested are not within the agency's possession, and you forget to add not, and the records requested are within. 9 times out of 10, the OR will pick up on something like that and touch base with you to make sure, hey, do you need to submit another affidavit? This one seems to be contradicting your legal position as far as these records do not exist. But even in a substantive context, if you're dropping words or missing concepts, that can really confuse and muddy the waters for the appeals officer, and you're trying to make it as clear as you can for the appeals officer to make the proper and right decision in these cases. And again, eliminate language that makes the affidavit contradictory. I think you've seen affidavits like this before, haven't you, Kyle, where you get to the end of it and go, what? You just said it 2 or 3 different ways and contradicted yourself.
Yeah. Every so often you'll see an affidavit or attestation where the affiant seems to be almost fighting themselves while they're writing it. Those are ones that would benefit greatly from some heavy editing.
And again, that hour or 2 break or a day break, if you can, to go back and read it, will probably show that up and help you be able to fix and change that. Follow up from the appeals officer. The appeals officers will reach back out to you many times for additional information. Do not take it personally. It is not an attack on your character. It's not an attack on your credibility. Many times it's just an issue of more detail is needed, and take it as that, and take that almost when the appeals officer reach out, take that as a hint that, okay, something's not clicking here, or we're not on the same page with respect to my affidavit. Again, it could be an issue of more detail. It could be an issue of explaining the terms or the acronyms. It could be you needed to explain your storage process and how your database works. And Kyle has said this earlier too, stated fact is better than implications and inferences that come from that. We want to get definitive facts from you to the extent that we can, so that we can make a definite and concrete decision without using the words, could be, appears to be. We don't want to be there. And if you're there doing that in a affidavit, then you should really take a step back to bring some more clarity to the situation and to the affidavit.
Yeah. One thing I would add is for agencies, don't just assume that the appeals officer will reach back out to you if the affidavit or attestation isn't good enough. It's your burden of proof. The appeals officers aren't reaching back to give you a second bite at the apple. They're generally reaching back to you to clarify details, certain things they don't understand. If there's an obvious error that they think needs corrected, if there's a case that needs a court case that needs to be addressed that hasn't been addressed to this point. But I would stress that don't just assume that the appeals officer is going to help you out in this regard.
Yeah, because that can, that's a very good point to not make that assumption, because that can really lead to a number of problems with your final determination. And like I said, the courts have been less and less receptive to accepting and taking additional evidence on appeal. And I mentioned this earlier, to look to cases, final determinations, court cases that are similar to yours, where the similar exemption was cited or similar records were requested. It's good to look at why the court or the OR said the affidavit did or did not support the argument that was raised by the agency. So it's good to look at some patterns. The case list, we have a case citation list, which you can use, which is relatively easy to use, but even more so, you can search our final determinations and do so by description, by term, by exemption. So it should be a relatively easy process for you to track down some final determinations that are similar to the ones that you similar to the case you're handling before you, like if you get a request for a certain specific kind of record. You can use our docket search, and that's what that's for. Like I said, there's any number of terms that you can use to track down similar situations. Again, like I said, there's a number of different cases. You can potentially reference this one, and even in the situation where it may not relate to records, this case related to outstanding fees. Again, the court's going to want, and the Office of Open Records, as a result of the court's wanting, additional information and information that supports your legal argument. So in this case, the record said that the records were copied and prepared for the requester. The requester didn't pay. He had an outstanding balance. And the OOR accepted this one, and the court said that the affidavit needed to go one step further and identify the documents that were copied, as well as the number of pages included in the charge. So there could be a number of additional affidavit information that you could provide there. I got a question. In a case where a school district submitted an affidavit that falsely claims were posted online, what are the ramifications? As far as the Office of Open Records doesn't have the ability to press charges. That would be a criminal matter that a individual would need to make to the county district attorney's office or to the Office of Attorney General. But in the case of a school district and any allegations involving a school district, that would go to the county district attorney's office in which the school district was located. I know there's a couple school districts that are located in 2 different counties, so I'm not even going to address which one that would go to, but look to your county district attorney's office.
Yeah. And I would add that, during the course of the appeal, both parties can provide evidence. So both parties can provide their own, affidavits or attestations. So if one party provides evidence that the other party feels is false, they could always submit their own evidence in a manner that they think helps clarify things. If we did get some sort of evidence that has clear, falsehoods in it, that might affect the credibility of whether we accept the other statements in the affidavit.
Is that answer the question incomplete? Is that the other participant? Is that on the other participant in the appeal? So let me know if that answers your question. Again, on any of these questions, if you have follow-up questions, feel free to touch base with Kyle, me, or George Spees. So again, another case that discussed some of this is a very general. Okay, question was answered. Good. So this case gives a more general discussion on the adequacy of an affidavit and some of the things they look into. It's all things that we've covered already, just kind of reiterating. Includes detailed information describing the nature of the record sought, and then connects the nature of the various records to the exemption. So again, you're drawing that parallel, you're connecting the dots and explaining the facts and why the facts make the records to be under the exemption so that they are not public, to meet agency burden. This is just a list of court cases that I've thrown in at the end. Again, looking at reiterating everything that we've said in the presentation here today, just so you know that it is not the Office of Open Records that is determining these necessarily. The courts have backed up a lot of what the OOR wants with respect to attestations and affidavits. And in fact, they've even taken it a step further at times, wanting us to get even more detailed affidavits from agencies in support of the exemptions they cite. That is the end of our presentation, and I will give it a couple minutes here as we wrap up to see if anybody has any additional questions. And like I said, I'll give a couple minutes for that. Thank you all for joining us on a Sunshine Week, and hopefully you will have a great rest of the week and enjoy some of the other webinars that we're presenting. All right, seeing no questions, I will end it now. And like I said, I hope you all have a good afternoon.